Hello, my name is Richard Wenner. I'm a lawyer, and my passion is wills, estates, and estate planning. In this video, I'll explain what happens if you die in British Columbia without a will. Essentially, a will does two things. First, it appoints someone to act on your behalf, and that person is called the executor. The will grants to the executor immediate authority to make decisions with regard to your estate. The executor has legal authority to determine burial plans, to pay bills, to hire a lawyer, and to make whatever decisions may be necessary to implement the wishes of the deceased. Second, the will explicitly states how and to whom your estate will be distributed. If you die without a will, no one, including your spouse, has legal authority to make any decisions with regard to your estate until the court appoints a trustee. This court order is called a representation grant. This means that the funeral cannot be paid by the estate, no one has authority to pay bills from the estate, no investments can be made or renewed, nothing can be sold. The estate will be in limbo until that court order, the representation grant, is issued. Obtaining the grant can be expensive and time-consuming. The trustee whom the court appoints is typically, but not always, the first person in line to inherit the estate. This makes sense because the beneficiary is in the best position to preserve and to enhance the value of the estate. In an estate that has no will, the order of inheritance is dictated by British Columbia law. These rules are ironclad and they are unbending. The order of inheritance is dependent upon who survived the deceased. For example, if the deceased was married or living common law for at least 2 years prior to death, and if the deceased had no children, then everything goes to the surviving spouse. If the surviving spouse had children with the deceased, and the deceased had no children from any prior relationship, then the surviving spouse will receive the first $300,000 from the estate. The remainder is then split equally between the surviving spouse and the children. If the deceased and the surviving spouse had children together, and the deceased had children from a prior relationship, then the surviving spouse receives the first $150,000 and not $300,000 from the deceased estate. The remainder would be split equally between the spouse and all of the children. This could create real hardship to the surviving spouse. If the deceased left children under the age of 19, their inheritance must be placed with the public guardian and trustee for safekeeping until age 19, when the funds will be released in full. If the inheritance is sizable, a significant gift at this tender age could have devastating consequences. Before the child reaches 19, the trustee controls their funds. This means that if the underage child needs money for items like education, housing, sports programs, or lessons, the legal guardian must apply to the public trustee to have it released. One more wrinkle. The law was recently changed. In the past, the surviving spouse had the right to live in the deceased's home for the remainder of their life, but no longer. If the deceased was the sole owner of the couple's home, and the surviving spouse chooses to remain in that home, he or she must buy the home from the estate within 180 days of the date of issue of that representation grant. This can create real turmoil. If the deceased had no spouse and no children, then the deceased estate is allocated equally to his or her parents or to the surviving parent. If there are no parents, then the estate is divided equally amongst the deceased siblings. If one or more siblings is not alive but had children, then that surviving sibling's share is distributed equally amongst that deceased's siblings' children. One more critical point. The law requires that the estate be distributed not more than 4 degrees of separation from the deceased. If there is no family member closer than 4 degrees of separation, then the estate goes to the provincial government. This means that if the only surviving heir is a child of the deceased's first cousin, the beneficiary would be the government. All of this is to say that dying without a will has consequences for the ones you leave behind. One of the most responsible and loving things you can do is to ensure that your loved ones don't have to go through this by having a legal and up-to-date will. I promise you, it's not nearly as complicated, time-consuming, or as painful as you might believe. I will walk you through each step of the process. Give me a call. I look forward to working with you.